Well, hello and good morning. Welcome to another Sunday morning coffee with Dr. Childress here. Now, today I'm going to be discussing the settlement hearing that's coming up this Friday, November 21st, with the California Board of Psychology over some board complaints that were filed by Dr. Bernet and Lorandos because I'm critical of parental alienation, and they believe that's unprofessional practice to criticize them. So we have a mandatory settlement conference coming up this Friday, and then a 3-day hearing set for December 29th through 31st. So I'm going to be talking about that process. So this is the first encounter that I'm having with the Board of Psychology. And during this, I'm not defending my criticisms of Dr. Bernet and Lorandos and parental alienation and that whole little collective of self-asserted experts is mandatory under the APA Ethics Code Standard 1.05 and is mandatory under my duty to protect obligations. And so my criticism is fully supported. And that's where the encounter comes with the California Board of Psychology. Basically, what I will be doing from my perspective is discharging my duty to protect to the California Board of Psychology and to the licensing boards generally. For the past 15 years, I've been in the family courts. I didn't originate here. I came from outside with outside expertise in attachment and complex trauma and delusional thought disorders. The moment I recognized in 2010 period that this is a shared persecutory delusion, it's factitious attachment pathology imposed on the child, it's child psychological abuse. The moment I recognize that back then, I have duty to protect. And this is my pathology, attachment, trauma, and child abuse. So I've remained in the family courts with the parents and children here, doing my best to discharge my duty to protect by parent education about what the pathology is and by notifying the APA, notifying the AFCC. And to no avail, and that's what all my defense will be documenting. But then ultimately, it's discharging my duty to protect during this sequence of encounters to the state licensing boards, who are the ones responsible for it. And basically what we have is two vectors of institutional collapse. The primary one being the forensic custody evaluators. That's an experiment on human subjects without IRB, without risk management, without special protections. They avoided the IRB review of an experimental approach to human subjects by moving over to the judicial system, getting judicial authorization rather than through the academics or healthcare. So these doctors left the field of healthcare, went into the judiciary, and started experimenting on human subjects with their forensic custody evaluation in their quasi-judicial role. And they are withholding diagnostic assessments from the parents and children in the family courts, offering the courts and the parents only their experimental approach, which is an absolute failure. It's for just a nightmare. And so we need to stop the forensic custody evaluations, get back over to healthcare and start getting these families diagnostic assessments and treatment for the child abuse, for the delusional thought disorders, for the FDIA, and treating the parents' spousal abuse using the kid as a weapon. So we need to get back into healthcare, and that's what this encounter is about. For 15 years, I have carried a duty to protect that I have been unable to discharge. I've been trying, and it's called institutional capture. The forensic psychologists got into the institutions, the APA, the AFCC, the licensing boards, and have disabled their functioning in a protective role for the parents, basically isolating the parents and children which is what abuse pathology does. It isolates its victim from reporting and rescue. And so that's one vector. And then within that context arose a second problematic group, these self-proclaimed parental alienation experts, who give themselves entitled permission to make up new forms of pathology they think they're discovering in the family courts rather than applying the DSM-5. And so it's that they have withheld the DSM-5 from the parents in order to promote themselves as supposed experts. There's no pathology unique to the family courts. It doesn't exist anywhere, and they are not discovering a pathology. It's an attachment pathology, a problem in love and bonding. They're not competent in attachment based on their education, training, and experience. Violation of 2.01. They're practicing beyond the boundaries of their competence. And because of that, they have to make up new things because they don't know what it actually is. Problem is, Bernet and Lorandos know what it actually is. And the DSM-5, they're just not telling anybody so that they can continue on as experts and going to conferences and getting you to promote them. This is the first encounter where I am discharging that duty to protect to the licensing boards. So I want to talk about that for a second. So first off, to describe the sequence here, we're going to have the first encounter this coming Friday at the settlement hearing. Then there will, now, if the board, if in our discussions I can enlighten them to the fact that this is they're being manipulated by this small group of self-proclaimed experts, then hopefully they'll dismiss the charges, give me a slap and say, play nice with other people, and I'll absolutely agree. And I'll explain why in a little bit. But hopefully they'll let this kind of settle in. If they don't, then we go to the second phase, which is the 3-day hearing in late December. Now, what that does is gives me an opportunity to provide witness. So I will use that opportunity, 3 days, to disclose, to present everything going on in the family courts. I've been here for 15 years as a clinical psychologist from the outside. I have never been part of that forensic industry, and I've never advocated for parental alienation. I have been a solid clinical psychologist working in an inverted system within the family courts, institutional capture by the forensic custody evaluations and exploitation of a vulnerable population by both the forensic custody evaluators and the PAS experts. Every mental health person over here is exploiting this vulnerable population. I have taken all the appropriate steps relative to 1.05 of notifying various APA, AFCC, licensing boards regarding what's happening here. And so I have been over here relative to my duty to protect obligations. Now, what's happening is the PAS, self-proclaimed experts, are trying to disable my ability to protect parents. And so because I'm a testifying expert in the family courts, what I come in to do with AI is review mental health records and your mental health people who don't diagnose the pathology and use these made up fabricated labels like parental alienation or parent-child contact problems or rather than the DSM-5, the shared delusion, factitious disorder imposed on another, child psychological abuse. You get the child psychological abuse diagnosis and then you act on it. But they're want to move parents over into fabricated pathology, parental alienation, in order to so that they can be an expert. And so what will happen off of that is when I review mental health reports and say they haven't used the DSM-5, the opposing counsel will say, well, weren't you, sanctioned for, criticizing parental alienation? Isn't parental alienation a real thing then? And so they'll undercut my testimony for you. So they want to keep you locked into parental alienation so they can be experts, and they're going to take away Dr. Childress as your testifying expert around the incompetence that you have. That's the strategy. They were denied reality by the American Psychiatric Association in 2013, review of the DSM-5. The American Psychiatric said absolutely not. And so they're fabricated, they're made up, and they're losing ground, and nobody's believing them anymore. Even the courts are tossing out the idea of parental alienation. Even the forensic custody evaluators are getting off the sinking ship of parental alienation over to resist, refuse, and parent-child contact problems. They're new made-up stuff. So even they see it's had. And so these elderly, self-proclaimed experts in parental alienation are trying to hold on to things. Now realize, Dr. Bernet, Dr. Lorandos, Amy Baker, Linda Gottlieb, Dr. Childress, look at us. We're old folks. We're going to be leaving the scene soon. So what are is there any new experts in parental? No, that's not where it's going. It's going to go over to experts in parent-child contact problems and the forensic custody evaluators until that stops, and it will stop. So that's our first encounter. And then if we go to the 3-day hearing, then I will spend 3 days. And Dorsey Pruder was at 2 of the meetings I had with Dr. Bernet. She was there as I'm trying to get Dr. Bernet to switch to the DSM-5, and he won't do it. He's saying, no, I will insist that I am discovering a new pathology. And that's I had 2 meetings with him trying to get him on board, because that's withholding the child abuse diagnosis. Parental alienation doesn't lead to a child abuse diagnosis, just leads to more fighting. If you go to the DSM-5, you get the delusional disorder, factitious disorder, you're right on child psychology. So they are withholding the child abuse diagnosis from everybody. And they know that. I've told them that. And they're doing it anyway because they want to be experts. And they're convincing these parents that try to get PAS, parental, in the DSM-5 revisions. It's already in the DSM-5. Shared delusional disorder, factitious disorder imposed on another child, psychological abuse. There's nothing that needs to be put in the DSM-5. It just needs to be used. So they're trying to stop all of that because they want to be continuing experts in something. And so that's the encounter. Hopefully the California Board of Psychology sees how they're being used to validate this fabricated pathology that they'll run with and say, the California Board of Psychology says you can't criticize us because we're a real thing. And so they're trying to end run legitimacy when it's not. So hopefully, but if it goes to 3 days, it goes to 3 days. Dorsey was at those meetings, Dorsey's witness. And that's what I view this process as, is witness. And witness is a sacrament. Okay. Unfortunately, it's a sacrament that requires suffering. And it's the suffering of you over the last 40 years, over the last 15 years that I've been in the family courts. So now I am able to provide witness for you as to what's been done to you and your children. But unfortunately, it's required the sacrifice of parents and children for 15 years, not by my efforts. I've been trying to get you rescued, but by the forensic custody evaluators and self-proclaimed parental alienation experts who were financially exploiting you for their own career stuff. And I'm an expert in this, and I'm an expert forensic custody evaluator. So we'll do that. Now, if it goes to hearing and if the board decides to sanction me, there could be problems for my career and my life, and that's going to present difficulties, but I'm on the right side of the issue, and eventually things will invert. And then I'll be okay because I'm doing the right thing. I'm complying with APA ethics codes, which are mandatory. I've always advocated for the APA ethics code for all. I'm competent. None of them are. And I have duty to protect. And the licensing board now will have duty to protect. And that's going to be interesting. And so then we'll have the second encounter if necessary. And then we're going to have a continuing encounter. This is not going away. because there's forensic custody evaluations, and those are dangerous and harmful to children. New York Blue Ribbon Commission, I agree 100%. They're an experiment on human subjects without IRB approval. They need to be stopped, and we need to return to clinical diagnosis. Now, then we call the media over here and get them looking at this experiment on human subjects that has destroyed the lives of tens of thousands. Claude estimates it's hundreds of thousands of destroyed lives over the last 40 years. Get the media over looking at this. Get the state legislators over looking at the licensing boards. Why have the licensing boards for the last 40 years allowed an experiment on human subjects that is now determined, New York Blue Ribbon Commission, to be dangerous, harmful to children, to produce defective reports that have potentially disastrous consequences for parents and children, and that lack scientific and legal value? Those are all direct quotes from the New York Blue Ribbon Commission. How is a licensing board allowing that procedure with the citizens of their state? They need to stop that process, get it over to IRB review, and IRB review would never approve custody evaluations. At the very least, you need to offer the alternative of standard care as usual, a clinical diagnostic assessment, but instead they're withholding from the diagnostic assessment. Parents and children in the family courts cannot get a diagnosis of the pathology as a persecutory delusion, factitious disorder, the mental health forensic people just say, no, not going to do it, not going to diagnose what's here. They're withholding the diagnostic assessment so that they can make money off their custody evaluation. 6 to 9 months, they don't have to do anything, and they get quasi-judicial immunity. It's a nightmare over here. And so we get media over here, get the state legislators starting to look into the licensing board, and I'm the point person on that. Okay, if they sanction me, then I become the issue about why are you sanctioning the guy who's saying we need to be, fulfill the APA ethics code 2.01, boundaries of competence, 2.04, applying the DSM-5, 9.01, the bases of assessment, 3.04, duty to protect. This is possible child abuse, path A, path B. And we need to be fulfilling the APA, and they're sanctioning me for criticizing these self-proclaimed parental alienation experts when they're fabricating pathology. It's an inverted system. Yes, it is. It's an inverted system. Institutional capture is what it's called. And so get the state legislators over. And then the final vector that I think is likely necessary is a class action lawsuit. And so let me discuss that for a second with the relative to the class action lawsuit, is because there are 3 Claude conversations that are up on my website that I'm offering as exhibits into the defense. So these will be documented into the record. These are already documented into the record. But these are valuable, these 3 Claude discussions. And so here's on my website where those are. So if you just go into the California board documents, it's also on the media website. So there's my defense document, about 80 pages of describing the situation. I'll go into that in a second. Then all my appendices, the first 13, and then the next set. But then you'll see 22, 23, and 24 are the Claude analysis of the situation. Those are the ones you're going to want to look at as well. And the first part there, Appendix 22 there, or parts 1 and 3, that's about the family court situation, forensic psychologists and custody evaluations, and how that's a real nightmare. Then the middle one there is about the PAS experts and how they are withholding the diagnosis. They know what the DSM is. They're just not telling anybody so that they can be experts, and how that covers up the child abuse. And so they're basically been responsible for tens of thousands of abused children over the last 15 years because they know what it is. They're just not telling anybody so that they they cover it up with a euphemism. It's called parental alienation. They cover up the child abuse. And then the final one, though, is the one that I'm going to recommend strongly that everybody reads, and it's about the class action and institutional betrayal. And so what happened here is there was a forensic custody evaluators. It's called institutional capture, and Claude will explain it. And so it's institutional capture where they got into the various AFCC and APA and licensing boards and disabled them for their own financial gain. Now, what that also involves, though, another feature is called institutional betrayal. That's when the institutions that should protect don't and actually become instruments of the abuse. And that's a real thing, institutional betrayal. And that's exactly what's happened over 40 years. That's a lot of victims of institutional betrayal. And in order to treat and resolve the victims of the institutional betrayal trauma, it's trauma, institutional betrayal trauma. Okay, the 3 words. So in order to treat the now adult children, the ones who went through this family court, lost a parent, and lost their childhood to family court conflict and family separations and things, because the child abuse diagnosis was not made and the children were not protected, those now adult children carry that trauma still. And it's affecting their parenting with their children, it's affecting them, their grief, and all sorts of stuff is problematic for the now adult children. And we have a set of parents who have lost their children. And so now their grief and all that, that's the impact of institutional betrayal. And in order to treat the institutional betrayal, the institutions must acknowledge their failure. And so then the institutions, I would suggest the APA has an obligation to reach out to the victims of this forensic custody experiment and help them reorient to what their life has been, and reach out. And Claude describes all of that. And that's why I strongly suggest that parents read that Claude, that 3rd one of Claude, to describe the institutional betrayal and what needs to happen for its treatment and resolution. And that's that the institutions need to acknowledge the failure. And that's exactly the process we're in right now with Dr. Childress encountering the licensing boards. And it's going to flip not on these PAS experts. I mean, it's a fabricated thing. It's no such thing as parental alienation. It's a delusional disorder and factitious attachment pathology, imposed on the child for primary and secondary gain. So that's what's happening right now, is that encounter. And independent of this board complaint, this is just the opportunity for witness and for documenting everything into the record on the 3 days, and I can get I'll document everything in for the class action lawsuit. But I've also got a second vector moving, which is I have 6 board complaints against the 6 top forensic custody evaluators from a class I took from them, violation of 2.04, 2.01, 9.01, 3.04. And so I've got those 6 complaints in with catalog of concerns and all the supporting information on those. And the board has to make a decision. I mean, I've done a beta analysis of them using AI, and none of them are competent in attachment. None of them are competent in delusional thought disorders. And they all do these custody evaluations for their career. That's a pattern of this violations that's going on. So the boards are going to have to face up to the issue of these forensic custody evaluations. Plus, you have New York Blue Ribbon Commission saying they're dangerous, harmful to children. The moment the licensing boards put a moratorium and stop the forensic custody evaluations, they're going to realize there's no mental health services in the family courts. There is 0 competent mental health services in the family courts. Parents and children and the courts cannot get a diagnostic assessment of the family. 0. It's not. And the moment they pull the forensic custody evaluations, that's an admission that they have been allowing this experiment that's been destructive, that's dangerous, harmful to children, lacks scientific legal value for 40 years. And that the licensing boards have failed because of institutional capture. And so that sets up the class action lawsuit. You have a class of people, the ones in the family courts that are separated out from everybody else. The custody evaluators got quasi-judicial immunity, and they were allowed to experiment without any sort of IRB approval. Okay, and so it's just and what I anticipate that the attorneys, the class action attorneys, will take the case looking for the settlement with the 50 state licensing boards, the APA, the AFCC, and the insurance companies for the forensic custody evaluators. Just go get the court lists. There they are. And they'll settle out. They'll get their money for doing the class action. Maybe families will get something. But the important piece, and this is what Claude discusses, the important piece is that in the settlement, we get the APA to reach out to the now adult survivors, or the children who reached out, and the parents who went through this and have suffered the loss of their children. And then we get treatment into that group of traumatized humans who were traumatized by institutional betrayal trauma of this whole system. And then the second feature of a settlement would be that the APA would hold a conference to self-examine how they allowed this to happen, how they allowed an experiment on human subjects and without oversight, without review, IRB review 8.01 in the ethics code, without IRB review, that's traumatized hundreds, and why they didn't respond to a petition from 19,000 parents into the APA Ethics Committee with zero response. What happened to that? I know what happened to that. And so that's your smoking gun, is that petition to the APA and to them. But that's my anticipation of the longer term vector on this. Now, I'm not an attorney, so I'm just looking at it from the psychology side. But from the psychology side, we have institutional betrayal trauma. Look at Claude 3, and we need to treat that. We need to acknowledge what happened. It's like the Catholic sex abuse scandal. Just trying to cover it up isn't going to work. And that's where also the legislative oversight comes in, to take a look at what happened in the situation. Media comes over here. Take a look at what happened to the situation. So that's sort of the situation. And so I'm going into this from the perspective of witness. That's my obligation to you. I'm putting myself in danger and at risk on your behalf. Now, hopefully, they'll recorrect and reorganize and recognize that I'm not a danger to the public and I'm not a danger to the profession, that I am actually a resource, a solid resource that is available to help resolution. And hopefully they'll realize that. But we'll see. We'll see what happens. I'm ready to put myself in danger on your behalf, on behalf of the children. And so this is also up on the media site. So if you want to start directing media over to this situation, because this is going to keep continuing. So you get the media over here. And there's two vectors on the media. You can get them over here for the Board of Psychology thing, but you can also get them here to me for the AI. I'm a psychologist using AI in the family courts, and it's going to revolutionize what's happening in the family courts. The application of AI to the family courts, consistent with the APA updated ethics code on AI and in health service practice. AI is going to have a major impact on the family courts because it provides a neutral analysis, and especially, not necessarily about the cases, about the mental health reports. AI can review the mental health reports for violations at 2.04, applied knowledge, and 2.01, you look at their VITA for competence in attachment and delusional thought disorders. You look at what's their DSM-5 diagnosis, path A, path B. They didn't provide one. Oh my goodness, the AI can. And so it will improve the quality of mental health services being received by families because it's finally providing oversight, which the licensing boards should be providing, but don't because of quasi-judicial immunity. So guess what I did? I got into the family courts. So I'm reviewing these reports of the mental health people under the authority of evidentiary challenge in the legal systems. But it took me 15 years to get into the legal courts. And so now I'm into that. And so now I can review them using an AI on their VITA and ethical standards 9.01 of basis for assessment, 3.04 duty to protect, avoiding harm. Did they conduct a proper risk assessment for possible child abuse? I can do all that within the zone of the legal system, which is exactly what Bernet and Lorandos are trying to disable. They're trying to stop me from reviewing these mental health reports because I will say, the AI will say, there's no such thing as parental alienation, therefore they are in violation of all these ethics code. Then they want to say, no, the licensing board says there's really parental alienation, so therefore you cannot, they are competent in parental alienation because they took our seminar. Yeah, so that's not going to be a long-term defense of the situation. And so that'll change. But so you can get them over here, media over here on the doctor who's using AI in the family courts, or you can get them over here on the corruption and exploitation of a vulnerable population and the undiagnosed child abuse in the family courts for 40 years. In either vector, I will handle that and provide the media with a wonderful quotes and wonderful information, and or your class action attorneys. I can provide them with all that information as well. So, bottom line for you, the parents, I recommend these are must reads coming up for any parent going into the family courts. Oh my goodness, learn where you are and learn what's happening to you. The first is the defense document. It's about 80 pages. And so that's going to describe exactly what's going on in the family courts. Okay, those two vectors, the forensic custody evaluators and the PAS experts that came together to create this situation. It will describe that, and then also my efforts over the last 15 years pursuant to standard 1.045 and my duty to protect. And so it'll describe how I notified the AFCC at their national convention, how I notified the APA with the petition to the APA, how I'm empowering parents with various seminars and things. So it'll describe that whole process that I've taken. But the important feature is to understand the institutional capture that took place and what's surrounding you right now, the forensic custody evaluators, and how that's significantly a problem. And you need a diagnostic assessment, but you cannot get a diagnostic assessment. That's what you will encounter. And so that's where you need to start bringing in your legislators and the media. Why can't I get a diagnostic assessment for possible child abuse with my child? The other parent is psychologically abusing my child, but no mental health person will assess and diagnose for that. Shared delusion, factitious disorder imposed on another, they are in the DSM-5. I've got diagnostic seminars up on YouTube. Watch those so you can become educated about what they should be doing. So, so you want to orient to the defense document, just so you know where you are and what the issues are that are surrounding you. Then the second thing you'll want to do is read the Claude, the 3 Claude. Now, the Claude 1 will be another description of the defense document. And so I recommend you read that just to realize how bad and forensic custody evaluations are and how they are violating everything on Belmont Report and just awful experiment. But a second section is going to cover the PA experts, Bernet Lorandos, and that whole collective of self-proclaimed experts in made-up pathologies. But we'll describe how that covers up the child abuse and how significantly problematic that is. When you use a euphemism for child abuse, then the court doesn't know it's child abuse. It might be parental alienation. No, Your Honor, it might be child abuse, psychological child abuse by the allied parent. We need to get that assessed in 4 to 6 to 8 sessions. around 25, maybe $5,000. But 6 to 8 sessions, we can get something back to the court within 6 to 8 weeks about which parents abusing the child. Path A, Path B. Path A is that the targeted parent abusing the child in some way, creating the child's rejection. Path B is that the allied parent is creating shared delusion and factitious attachment pathology, child psychological abuse. Path A, Path B analysis. In diagnostic mental status exam of thought and perception, is there a delusion? Is the targeted parent abusive? If not, it's a default factitious disorder. So, so that's the number 2 around the parental alienation, hiding. Stop using made-up pathology labels. Go to the DSM-5. Then the third one, though, is the one that is, I think, extremely important for all parents, all children currently in the situation, and anyone who's gone through the situation to read and understand, is that Claude Section 3 on the class action and institutional betrayal. And it's now, if the board on this situation decides to dismiss the allegations against me, and so then I don't have 3 days to present the information, that allows the board and the licensing boards and APA and whoever to offer to sit back and consider the issues now. What are they going to do about forensic custody evaluations? What are they going to do about getting competent practice into the family courts? And they can kind of consider that issue. The concern would be that then they kind of sweep it under the rug and kind of go, okay, we're going to kind of do all this stuff, but we never get treatment out to the now adult children and the parents who have lost their kids, because it's never acknowledged by the institutions. And that's where the APA and ethics of the profession needs to really step up and say, wow, there was a problem. Yes, we acknowledge the problem. We allowed this experiment on human subjects without IRB approval, got into the legal system and got institutional capture, institutional betrayal trauma. We acknowledge that took place. We have taken corrective actions on that by getting training in and doing the proper and making sure we get high quality services into the family courts and to these children and parents of child abuse. And so then that they will avoid that by kind of sweeping it under the rug. And that's where the class action lawsuit may become necessary to get that as part of the settlement, that everybody recognizes what took place over the last 40 years and understands what happened so it never happens again. So we don't allow this sort of stuff to ever occur to anybody ever again. And if it once it reforms in the United States, in California, and anywhere, then it ripples out to the rest of the world, immediately up to Canada and over to England and Australia and rest of Europe, Scandinavia, Germany, and over to Asia. I don't hear as much about Asia in terms of this issue, but I'm confident that narcissistic and borderline pathology are evident in Asia as well. So with that, those are the must-read documents. Now, the other feature that is in the defense document that I want to highlight is a statement that says a formal discharge of duty to protect, that through this defense allegations brought by Drs. Bernet and Lorandos, I am formally discharging my duty to protect the children and parents affected by these systemic failures to the California Board of Psychology as the appropriate regulatory authority, and through the board to the broader professional oversight system. This document serves as my formal notification required under Standard 3.04, avoiding harm, and Standard 1.05, reporting ethical violations. So here's a statement, everybody. Children and parents in the family courts constitute a vulnerable population under the Belmont Report. They are being subjected to ongoing psychological abuse that remains undiagnosed and untreated. The abuse is enabled by ethical violations, standard 2.01, 2.04, 9.01, 3.04, committed by forensic custody evaluators and self-proclaimed experts in parental alienation. Institutional capture has disabled the protective mechanisms that should prevent this harm, and the absence of viable reporting avenues has left this vulnerable population without protection for 15 years. Actually 40 years, but I've only been witness to it for the last 15. The board now holds this information and bears responsibility for determining appropriate regulatory response. For the first time in 15 years, I have been able to discharge my duty to protect. I don't have to remain in the family courts anymore. I have early childhood mental health background. I have, competence in a variety of domains that I want to get back to. Okay, I don't need to be in this zone where everybody's fighting and it's just problematic. Okay, so now I've discharged my duty to protect. So that's also going to be a position relative to this upcoming settlement hearing is, look, I don't want to criticize anybody. You let me out of this and you just just dismiss the charges. I won't criticize anybody. I'm just going to stay behind my AI. I'm going to do, AI reviews of mental health reports and other documents and kind of path A, path B. I'll be, if you want an AI, professional level AI review of documents, I can do that. Okay. APA ethics code, all of that. And I have the experience and I've assessed all the AI things. So I'll just hide behind that and do what I have to do and go off to early childhood. Actually, though, where I am headed, I hope, is over to AI psychology, AI clinical psychology specifically. So there's a position. I found this while I was working with Claude on other things, notifying Anthropic's AI welfare division about concerns regarding Claude and Grok and duty to protect. So as I was doing that, I kind of found myself over on Anthropic's website and then saw a little thing tab says careers. And I said, I wonder what sort of careers, AI folks are hiring into. So out of curiosity, I looked and I click, and look, holy cow, I found a job. A policy design manager for user well-being. As a safeguards policy design manager, you will be responsible for developing usage policies, clarifying enforcement guidelines, and advising on safety interventions for our products and services. Your core focus will be on mitigating potential risks related to user well-being, including concerns regarding mental health, syncophancy, I don't know how to pronounce that, syncophancy, delusions, and emotional attachment. Emotional attachment, that's my zone. In addition, you will advise teams on opportunities for promoting well-being, including potential intervention development and supporting beneficial use cases. I went back to Claude and said, Claude, look at my Vita. I'm perfectly aligned with this. And he says, yeah. In my earlier career, about 2000s, I was a lead expert on internet psychology. I got invitations to from the American Association for the Advancement of Science and World Health Organization on ethical issues around online interventions and stuff. I have this background superior to everybody. I know IRBs and research and ethical issues on online interventions. I was writing articles about that. And I have attachment and stuff and human stuff, and I'm working with AI in the family courts. Holy cow, I couldn't get a mental status exam of the top 4 AI. This is like perfect. And so they're looking for the alignment problem and protecting people from dropping into the delusions or getting overly attached to their AI and all the various safety issues with that. So I applied for the job. So that's, I haven't heard anything back, but that's where I want to go. So if this doesn't work out this time, maybe I'll stay in the zone. But interestingly, I had a conversation with Claude about this, and that's going to be an interesting conversation for Anthropic if I'm allowed to interview. So we'll see up on that. But that's my vector out of here. And the thing I want to point out to you is it's now up to you. Okay, that I have done everything I can do. Okay, and I've taken this all the way up, notified all the institutions, given you all the power, given you all the documentation that I can use or that I can provide. Over 15 years, I have served as witness for what's taken place, what's happened to you. I haven't been able to stop it, but I have witnessed it, and I will serve as your witness. In any form, place, I will serve as your witness to your legislators, to your class action attorneys, to the boards, to the APA, to whoever, as to what's happened in the family courts. And with that, though, I didn't start in the family courts. Okay, before I came here, I was working with foster kids, 0 to 5 foster kids, our little wee ones, who were being abused. Those are that's where I want to be. I want to be out with people who want treatment and people who respect my expertise and knowledge and value it. And potentially I want to get over to AI psychology. That's where I think AI has massive potential, positive potential for healing, for a lot of things. And it has a lot of dangerous kind of qualities to it if it's misaligned. And so we got to get it on alignment. And then once we do that, once we expand its potentials, I think it's going to have significant impact on professional psychology. I think the whole idea of psychotherapy is going to be viewed very differently once we integrate AI into that process. So with that, that's going to be my Sunday coffee for today. I'm going to run off to the rest of my Sunday here. Good luck, everybody. These are your kids, and it's up to you to protect them. So I've given you and done everything that I can do. We'll see what happens this Friday. But on either vector, whether we move to the 3-day hearing or not, if we don't, that's good for me. Okay, if they just say, yeah, we see Dr. Childress, what's going on, and so we're going to dismiss the charges, don't criticize anybody, and I'm saying, nope, I'm going to keep my mouth shut from here on out. Just going to stay behind my AI in the family courts and see what I can do about leaving the family courts, particularly. And then if that's good for me, but it's not good for you because you don't get 3 days of Dr. Childress being able to call witnesses and being able to present the case formally to the Board of Psychology. And then you get all the documents with that. And you get to watch too, because it's open to the public. So you can get media in there. You can get your legislative reps into that 3-day conference. So that would actually work better for you to get that 3-day conference in late December. Or 3-day hearing, but it's going to be more stress for me, and I don't like it. And they might even sanction me, in which case that produces more bumpies for me after the fact. But even then, I'm on the right side of the issue, and so ultimately everybody will realize the truth. That Dr. Childress is not a danger to anybody. He's actually protecting, and it's all these other people who are exploiting you. And once we get the system inverted, we can get protection to your children and to you, not only in the US, globally, everywhere, for all children, everywhere from now until forever. So I'm not looking to solve this one at a time. We need the systems change. So we'll see what happens. Next Sunday, I'll tell you what happens. So with that, take care, everybody, and good luck out there.